So welcome to this session, which is part of a project that we've had at the. It was actually the first project that was formally applied for and granted with sort of the base, the Central Non-Social Transformation as the base, and that was actually before the Centre was formally established. But we used that. Well, and of course it's also a CMI project, but and Department of Comparative Politics, but that's the first one that sort of provided formal, centre formally affiliated, project formally affiliated to the centre. So in that case, that's one of the reasons why it's special. It's been a really interesting project. It grew out of some earlier collaboration that Namita Bai, you will meet shortly, had with CMI and with me, and also collaborations that, or at least in exchanges and interaction that Kavita Soreda had with CMI and with me, and then it was sort of brought together the different agendas. So this is a project that looks at the Indian development agenda and sees that there are some very important tensions. Because on the one hand, there's a very strong need and desire to develop, and the main tool for this development is large-scale industrialization. And a lot of this industrialization affects areas that have been protected by laws protecting vulnerable populations and vulnerable areas, ecologically vulnerable areas, which has also been an important agenda in India to use protective laws to protect. Namita will talk more about this in detail, but protect groups and areas that have been seen as particularly vulnerable. So, in this clash, we would like to understand how does this tension play out in different parts of India. India is a federal state with very different laws and regulations, even constitutional provisions that are different in different parts of the country. So we would like to understand how does it play out, when do law actually work to protect groups, when does it not, who is usually using the law and so on. And on the basis, the main research partner is the Central Policy Research in Delhi, where Namita is based, and they've actually built quite a large unit at the CPR that started with this project and then has grown bigger. So what you see today is the fruits of a couple of years actually only of research on the part of CPR, and into an agenda that proved to be much larger than we actually imagined and a lot more politicized. As these are the issues around land acquisition have been at the forefront of Indian politics in this period. So it's very important, very difficult issues to sort of a lot of sort of true problems, true dilemmas, and we're very happy that you're here to help us engage them. So. Namita first, and then I'll introduce the others as they go.
Good morning, everyone. Let me start by thanking Siri and Ingvild, both of them, and all the other volunteers for putting together these wonderful Bergen Exchanges, and to all of you for the intellectual stimulation of the last several days. So, as Siri mentioned, my colleague Ankit, who couldn't be here because of a family tragedy, and we are the unit at CPR who've been working on this project on land rights in the scheduled areas. Yes. Okay. Thank you. What I realized over the last few days is how little I know about the various countries that many of you come from. So I thought when I start, I'll just give you a few quick facts about India to put the project into context. India is the 7th largest country in the world by geographical landmass. It is the 2nd most populous nation in the world after China, with over 1.26 billion people, and it is the world's largest democracy. Colonized by the British for almost 200 years, India became a republic in 1950 with the longest written constitution in the world. India is often described as a union of states. What that means is, as Siri mentioned, that we have a federal system of government, but with a unitary bias. In other words, the residuary powers of legislation are with the union and not with the state. We also have, as a courtesy of the colonial legacy, a parliamentary system of government, where we have the people elect representatives to the parliament and to the state assemblies. So, with this backdrop, let me get into the central question that we sought to investigate in this project. And that question, very simply, was this. There exist special protective constitutional and legal provisions safeguarding the rights of tribals or indigenous people to land, and also special affirmative action provisions for their uplift. But despite this, they continue to be the most vulnerable and impoverished of all groups in India. And really the question is, why is this the case? So let me first briefly describe the special differentiated legal regime and protection for the scheduled tribes in the scheduled areas. Then I will describe the dismal situation of the scheduled tribes, which, given these special protective provisions, warrants investigation. And finally, I will present some of our preliminary findings to this question. The legal regime governing the rights of the scheduled tribes, and I will explain why they are called the scheduled tribes in a minute, but they are the tribal people, is differentiated from the rest of the Indian population along several parameters. First, the tribals or scheduled tribes have both individual and group representation within the Indian federal constitutional framework. There are specific reserved electoral constituencies in majority tribal districts for both state assembly and parliamentary constituencies. Second, there are also affirmative action provisions that reserve 7% of the seats in government jobs and educational institutions for the scheduled tribes. And it's 7% because that was their proportional percentage in the population at the time of independence. And finally, and this is the focus of this project, there are also tribal majority areas carved out of the geographical landmass of India, which are designated as scheduled areas as demarcated in the 5th and 6th schedules. Now, there is a plethora of literature on scheduled tribes in India that has focused on their cultural identity, the historical injustices perpetrated against them by the British colonial state, their poverty, vulnerability, displacement, and alienation from the Indian state. The reason why in this project we are focusing on land and why it's different is because land, and especially forest land, is central to tribal identity, representation, and development. And these are the three narratives that I'm going to be developing on further. The scheduled tribes have historically been engaged in a variety of traditional occupations that have lived off forest land, whether it is hunting, gathering, collecting minor forest produce, shifting cultivation, and now increasingly, for a vast majority of them, settled cultivation. Land for them is integral to their identity, culture, and social and political life. Therefore, displacement from the land makes them economically vulnerable, but also it threatens to destroy their cultural identity as a group. So now let me describe the special constitutional framework that is outlined in the 5th and 6th schedules, which carves out these areas. And the scheduled tribes are called so because they have been designated as such or listed as such in the Constitutional Scheduled Tribes Order of 1950. The order currently lists 744 tribes across 22 states in India. Numerous additions and deletions have been made to this list over the last 66 years. Now, let me first talk about the 5th schedule. The 5th schedule provides for the administration of tribal majority areas in 9 states within peninsular India that have tribal minority population. So, let me just show you. These are the states, Andhra Pradesh, Telangana, Gujarat, Jharkhand, Chhattisgarh, and so on. And the ones that are highlighted are the project states, the states that we are looking into in the 5th schedule. The President of India can by order declare any area to be a scheduled area within the state. The currently designated scheduled areas, as I mentioned, are in these states. If you see, this is the map of India, and the areas marked in orange are all the states which have scheduled areas under the 5th schedule, and the areas marked in blue, those are 4 states in the northeast that have areas under the 6th schedule. And for our purposes, the project states we are looking at are Gujarat, and in the south, Telangana and Andhra Pradesh. So, according to the 5th schedule, these areas are to be administered by the governor of the state in consultation with tribes advisory councils to be appointed by the governor. So remember, so these are not representative bodies, these are advisory bodies that are appointed by the governor. And the governor can decide what laws to apply or what laws not to apply in the scheduled areas. He can also make regulations for the good governance of all the scheduled areas. Therefore, what we see in the 5th schedule is that there is a considerable centralization of power with the governor and with the president. What that also means is that legally speaking, there is no recognition of tribal sovereignty over the land and natural resources in the scheduled areas. It is the Indian state that has sovereignty over these areas. There is only a recognition of the special status of tribals and state-directed laws for their protection. Now, despite the governor having extensive powers in these areas, they have been rarely exercised over the last 66 years. All the 5th scheduled states have enacted laws also that prohibit the transfer of land within the tribal areas from the scheduled tribes to the non-tribal. So this is another layer of protective legal framework after the constitutional protections, the legal protections. But, for instance, the governor has rarely exercised his powers. And in 1996, we did enact the Panchayat Extension to Scheduled Areas Act, which did devolve some powers to the Gram Sabhas, which are the local bodies. So there has been some devolution of power since 1996, but before that there was a considerable centralization of power. Now let me talk about the 6th schedule, and remember these are the states in the northeastern part of the country in blue. The 6th schedule provides the broad framework for the administration of tribal areas in the northeastern states of Assam, Meghalaya, Mizoram and Tripura. So Meghalaya in bold is for the state that we are looking at. It provides for a system of scheduled areas called autonomous districts and autonomous regions within the districts to be administered democratically by the tribal population of such scheduled areas. These are the 4 project states that we are studying. Now, as you will recall that, and this is again them on the map, the project states. Now, as you will recall, from what I said earlier, the tribal population in India is spread over 22 states. That's the number of tribes listed in the order. But the designated scheduled areas are to be found in only 16 states. So we know that then there are many states with tribal population that do not have designated scheduled areas for the same. And even within the states that have designated scheduled areas, significant tribal population may be found outside of the scheduled areas. Moreover, we also find that there is considerable variation in terms of the percentage of tribal population with respect to the overall population of the tribal minority states in the scheduled areas, as well as within the districts, within the scheduled areas, there is variation in terms of tribal and non-tribal population. Now, most of the existing government reports and scholarly literature have focused on the tribal population overall and have not looked at the scheduled areas. So when we started working on this project, we realized that there is no statistical data on how much geographical area in India is actually within the scheduled areas. And so we began to collect primary data from the census at the district, and then below the district we have the tehsil and the village level to actually create data on scheduled areas and not the scheduled tribe population. And here we ran into a lot of problems in data collection with respect to the state of Andhra Pradesh down there. It used to be one combined state a few years ago, and now it has been bifurcated. And we found that there was a lot of difficulty in collecting data for the state. So, after extensive efforts, we still don't have data for a number of districts and scheduled tribe point areas. And I've now filed right to information requests with the government to collect this data. But we do have data for the other states. And what we found based on this extensive exercise is that we actually now know that 10.5% of the entire geographical area of India is designated as a scheduled area, which is a very substantial landmass when you consider the fact that India is the 7th largest country in the world by landmass. So 10% of India is very, very big. Of this, about 9% of this area is in the 5th schedule and 1.38% is in the northeast. If you look at the other figures, 7.17% of the total population of India lives in the scheduled areas. But this includes both the tribal and the non-tribal population. So now today, the total tribal population of India is 8.6%. But if we look at the tribal population which is living in the scheduled areas, it is only 30% of this tribal population. So clearly, if the scheduled areas were for tribal majority, designated areas, what we have now is that only a minority of tribals are actually living within the scheduled areas. Now this is a map which shows the percentage of geographical area in each state which is a tribal scheduled area. And so you see the pink or purple it corresponds to Meghalaya, where the whole entire state is a scheduled area. The project states that we have only 10 to 25% of Gujarat, and then the orange, the Andhra and Telangana, they are actually only 10 to 25% of their area is a scheduled area. And because we collected data at the district level, we actually, within those states, what are the districts that actually come within the scheduled areas, we are able to plot that as well. Yes. And this map actually shows the two put together. So we know that So we know that even in this state, the whole, Meghalaya we saw in the previous map, 100% is a tribal area. These states, not all area was, it was about 50 to 90%, but these are very dense congregation of scheduled area states where we have dense congregation of tribal majority. So we have data at the state and the district level which can help for a more contextual analysis. So now that we have some background on the scheduled areas, where they live, etc., let us talk about the gravity of the situation of the scheduled tribes. And here we find that poverty and landlessness is rampant amongst the scheduled tribes. More than half of all scheduled tribes are below the poverty line as compared to 37.2% of the total Indian population. So it's not as if all Indians are living in luxury. A large number are below the poverty line who are non-tribals as well, but the number is higher for tribals. 65% of tribals are landless as per the 2011 census, whereas the national average is only 40.2%. And the number of landless has increased drastically because you compare it with the 2001 census, it has really gone up. And what we find is that displacement has affected the tribal people in India disproportionately because, as I mentioned, the STs constitute only 8.6% of the total population of India. But they constitute 55% of the people who have been displaced since independence due to the construction of dams, mines, industrial development, and the creation of wildlife parks and sanctuaries. Therefore, it is very clear that these groups have disproportionately borne the burden of economic development. But let me go back again to the central question. We've seen that the Constitution does in fact provide this protective legal framework governing their rights to land and natural resources. It has these land transfer prohibition laws, yet we find that only 30% of them are living in the scheduled areas and that a significant number are landless. So what's going on? So now let me speak about the 4 project states, and we're doing a comparative study of these 4 Indian states that we chose based on our knowledge at the time, based on their geographical, political, population and constitutional diversity, and also where we had resource persons on the ground so we could actually do the work. Now, such is the dynamism of the Indian political environment that at the time we got the grant for this project in 2013, we planned to study 3 states because Andhra Pradesh and Telangana at that point were only one state. But at that point in time in 2014, shortly after we started the project, the state was bifurcated into 2 states. Now, all these 4 states show variation with regard to the numbers and concentration of tribal population, levels of social and economic development, socio-political differences, and current and historical federal dynamics. Andhra Pradesh, we now realize, is also unusual because unlike the other states where almost the entire district or a very large part of the district is designated as scheduled area, in Andhra Pradesh we have very small points of study composed of some villages spread across the state which are scheduled areas. So actually like 700 points of study, but they're very, very small and dispersed tribal population. So this is again just a few quick facts on these states to put it into context. I won't go through it in great detail, but you can see that all of them are high economic development growth rate states, ranging from 7.8% for Andhra Pradesh to 9.3% for Gujarat. And their per capita GDP ranking is again, Gujarat and Andhra Pradesh are more similar, but because they are higher up. Meghalaya is low in terms of per capita GDP ranking, but if you look at HDI ranking, then actually Meghalaya is way better. HDI, Human Development Index ranking, then Meghalaya is way better than Gujarat and Andhra Pradesh. And of course, economic freedom, Gujarat is number 1. So economic freedom and HDI don't always go together. So this is a map of Gujarat, and you see that these are the tribal districts in Gujarat, and they are all concentrated along the eastern side of the state. Now Gujarat, of course, is a state, as I showed on the previous map, in the western part of the country. It has one of the highest rates of economic growth. It is the highest in terms of economic freedom, and if you look at the tribal population of Gujarat, nearly 15%, 14.8% of the population in Gujarat is tribal in nature. Now, this population of Gujarat is also substantial because this is about 8.6% of the total tribal population of India. If we compare that with the other states, again Andhra Pradesh is a big state, so it's 5.3% of the population in Andhra Pradesh is tribal, and that is 5.7% of the total tribal population. Whereas if you look at Meghalaya, it's a very small state, so even though 86.1%, a huge majority of the population is tribal, it is only actually 2.5% of the total tribal population of India. Similarly, like now for Telangana and Andhra, they are now split, but these are the tribal districts in these states. And so what we find is that after we did the work, we found is that what is similar about Gujarat and Andhra is that they are both big states with high level of economic growth, high level of economic freedom, not very high human development indicators. But where they are dissimilar is in terms of the percentage of tribal population, because the percentage is about 15% in Gujarat, and it is lower in much lower in Andhra, only about 5.3%, a little higher in Telangana. So it's like if you plot a spectrum, then Andhra is here, and then Telangana, and then Gujarat, and then Meghalaya is way there. So that's why actually we realized that in order to have like a fuller analysis, it would have also been good for us. I'm just going back to this map to also consider another state from this part of the country, either Chhattisgarh or Jharkhand, because we have geographical diversity and we have also constitutional and political diversity. We have differences in terms of the tribal population because Andhra is less, Gujarat is more, Meghalaya is very high. But these states have about like a little less than majority tribal population, so between like 40%, and also in terms of the geographical landmass, they have about 40 to 50% of the landmass as the part of the schedule area. So now, finally, based on all the work we've done, there are sort of 5 or 6 preliminary findings about how we should understand these questions of displacement and deprivation of tribals. While they are based on the work that we've done in the states of Gujarat, AP and Telangana, and my colleagues Hugo and Kavita will talk about Meghalaya. But I believe that many of these points apply to a greater or lesser extent to all the 5th schedule and 6th schedule states. Now the first point is basically that the protective provisions contained in the 5th and 6th schedules do not exist in a vacuum, and they have to be seen against the backdrop of the larger framework of law and governance within which we operate. And this point sort of comes out from my doctoral work, which traces the law of eminent domain in India from the colonial period up until 1970, and it examines how state institutions in India, first the British colonial state and later within the independent Indian state, the various state institutions have reshaped property relations in land. Now, of course, the stated motivations of the British colonial state and that of the independent Indian state were quite different. The colonial state's stated motivation was to maximize revenue for the British Crown. The Indian state's motivation has been to redistribute property relations for the purposes of economic development and also to bring about social justice. But what we have is that even though the states change, there have been significant legal and institutional continuities between the British colonial state and the independent Indian state, which means that despite different motivations, the consequences of their policies for the interests of tribals and perhaps other traditional communities have been quite similar. So the contrary laws are, as you mentioned, the states plays an active role in displacing the tribals from the land through various laws of land acquisition for building dams, infrastructure, protecting forest land and mining. And this entire framework governing all of these laws is the contrary legal regime to the 5th and 6th schedules. So at the level of law itself, there are things cutting against the protections. But at the same time, both the enactment and administration of this contrary regime depends upon the broader political economy of these states. To give you an example, for instance, the construction of dams. Now, when we started seeing where all the dams in India are, we realized that it was a huge problem in the state of Gujarat relative to the others, because all the dams are in the tribal areas. And the 3 large dams, which are dams of national importance, are in the tribal areas. And Gujarat is a water scarce state. So their dams are the biggest cause of displacement, whereas in some of the other states like Chhattisgarh and Jharkhand, mining is the biggest cause of displacement. So the reasons may be different, but these are the broader reasons. Similarly, in terms of forest cover, we see this map which shows a considerable overlap between the scheduled areas and the forest cover in India, which makes sense because that's how the scheduled areas were in a way carved as well. Now, in the late 19th century, the British colonial state enacted a number of forest laws. Through one stroke of the pen, basically the British said that they have ownership over all forest land in India, and anybody who lives in the forest land is basically outlawed, right? So over the last 150 years, the forest department, which was set up as part of the colonial state, has basically been evicting tribals from the land. And as the state became more powerful through technology and so on, they were able to evict at a faster rate as compared to what they did 150 years ago. And now, even though we have a changeover in terms of the state itself, we have the same department and the same departments of government continuing, because we have the same colonial bureaucracy which continued. Now, some efforts have been made. I mean, it's not a linear process, because as I mentioned in 1996 with the Panchayat Extension of Scheduled Areas Act, and later in 2006 with the Forest Rights Act, attempts have been made to reverse this historical injustice by actually protecting the rights of the tribals. Nevertheless, most of the mineral wealth of India is concentrated in forest land. So what we find is that both the legal and illegal eviction of tribals from those states continues. And this was in context also of the discussion we had on climate change and so on, is that the biggest source of energy in India is coal. And coal mines are in the states of Jharkhand and Chhattisgarh, precisely where all of this forest cover is. So, I mean, this also relates to another aspect of the project relating to environmental depletion. But the juggernaut of the Indian development engine is such that, there's more and more mining, and there's more and more displacement, more and more erosion, and so on. Now if I can go back, yeah. The second point I want to make is that on all 3 intersecting narratives of development, representation, and land rights, the scheduled tribes are placed against the dominant mainstream. So when we think of the Constituent Assembly debates on scheduled tribes and 5th schedules, these were the 3 narratives that they talked about: development, representation, rights to land. So on development, the narrative is that the special status of the scheduled tribes is because their economic, political, and social way of life is considered not as developed as the rest of the population, and therefore they are particularly vulnerable groups of people. Now this is different from, say, the scheduled castes, which is another vulnerable group whose special status comes about because of a narrative of systematic discrimination. So the narratives are quite different. The scheduled castes have remained within Indian society, but they have been systematically discriminated against. Whereas the scheduled tribes have remained outside, always, the mainstream of Indian society, and have wanted to remain as such. So that's the first point. The second narrative is that of representation. That is, the scheduled tribes are represented through a group identity within the constitutional framework, which is different from the rest of the population. Because as I mentioned, they are represented within the tribes' advisory councils. There are also reservations, reserved electoral seats where tribal majority areas are there. And that is of course different from the rest of the population. Like Kavita and me, we have individual representation within the Indian state. We vote, but there's no gender reservation also. Here again, they are placed against the dominant mainstream. But remember, even where the seats are reserved for tribals, our research has showed that only 30% of the tribals are living in those places where the seats are reserved, and we have a first past the post system. So the candidate who's getting elected in these constituencies has to form a coalition, has to represent a coalition of interests, and not necessarily the tribal interests, even in the tribal reserved constituencies, let alone when the tribals are outside of those scheduled areas and in other parts of the country where they're obviously a minority, right? So how are their interests going to be represented? Yes. Therefore, and let me show you this in terms of, so we plotted these are the reserved parliamentary constituencies for scheduled tribes, and these are the scheduled area percentage to total district area. So we do find a heavy concentration of the reserved constituencies in the areas that are in purple, because those are where there is a large percentage of tribals, because those areas are themselves designated as scheduled areas. But for instance, tribals are living here and here and here as well, but the seats are not necessarily corresponding. So, clearly there is not, even in many areas which have scheduled areas, there are not reserved seats as well. So on various levels we see that they are not being sufficiently represented, right? The third narrative is that of their relationship to land. And here again, they have both individual and community rights to land, which again is opposed to the dominant mainstream, because again, general people in India do not only have individual rights to land, and the community rights to land were until the 2006 Forest Rights Act not even recognized. So again, their rights, the way they understand their relationship to land, was not really recognized and represented in the dominant legal framework. And that makes them particularly vulnerable to displacement. And then the third point that also comes out, which is very unfortunate, is because the tribal identity is not unified in any of the states. For instance, in the state of Andhra Pradesh, there are 33 recognized tribal groups, of which 8 are particularly vulnerable tribal groups. The rest are really not distinguishable from the rest of the population in terms of the fact that they are in settled rights to land and so on. But on each of these narratives of development, representation and rights to land, some of these groups are more dominant than others. For instance, in the state of Telangana, one tribal group called the Lambadas is deeply disliked by all the other tribal groups because they have cornered much of the benefits in the scheduled areas, because they are a dominant group, they are more developed, they are more numerically significant, and like in the state of Gujarat, there are 29 scheduled tribes, but 47% of the tribal population is only one scheduled tribe, and they have cornered most of the benefits. So, there is no unified tribal identity within the groups as well, and the most vulnerable within the tribal groups are also not represented. The fourth point is that there are problems of over-inclusion and under-inclusion within the listing of the tribes as well, because the tribes are listed by state. So we have the unfortunate circumstance that the Lambadas, for instance, they are recognized as a scheduled tribe in Andhra Pradesh, but in neighboring Maharashtra, they are not recognized as a tribe. So what we have is there has been migration of the Lambadas from where they are not recognized as a tribe to the state where they are recognized as a tribe, and they have cornered a lot of the benefits because they are anyways a stronger group numerically and in terms of protection. And finally, there are variations in the implementation of the 5th schedule across the states, and that comes from various factors, including historical factors, administrative factors, and so on. So I will conclude by saying that what we found is that it is impossible to map the potential and limits of social change through law without understanding how that law is actually effectuated. And that is done at multiple levels. First, financially, and here we looked at the budgets of the union government over the course of the last 66 years, and we found that only 0.2% of the actual financial budget is actually allocated to tribal uplift, even though tribals are 8.6% of the population. So 0.2, 8.6, huge gap there. And the second thing is in terms of the administration, because even when you've changed the law, for instance, we've changed the law to the Forest Rights Act to make the rights to recognize the rights of the tribals, but who is implementing the law? It is the Forest Department. Now, the Forest Department, both at the state and central level, comes under the Ministry of Environment and Forests. It was created in 1966, and basically the goal of the Forest Department was to protect forests and evict people who were living in the forest, and that's what it's been doing for all these years. And suddenly you've passed a new law, but the institutional legacy of the department hasn't really changed. And even though the nodal agency for implementing the law is the Tribal Welfare Department, they don't really know. The forests are huge areas of land which only the Forest Department knows and administers. So they have to depend upon the Forest Department to actually implement these laws, but the Forest Department is not cooperative. So there is interdepartmental, lack of cooperation and coordination and active sort of not obedience of laws. So there are things that we can do with laws, but there are so many other things we need to make sure that the law is effectuated. So I'll stop here now. Thank you.
Thank you, Namita. I think that was fascinating. A lot of information. I actually kept holding my breath. Very interesting. Jag bara skulle den av oss på den. What we'll do now is that we'll have Ans Nordtvedt from the Faculty of Law have a discussion with Namita, give her comments and a discussion about these issues, and then we'll go on to the state of Meghalaya. So you can just sit here. Yes. Because there are quite separate issues raised in the two parts of the project. So.
Me first now?
Yes.
Okay. Can you hear me? First of all, it's thank you, very interesting, and I'm a bit reluctant to comment so much because it's hard to understand. These issues are, you need to understand the local and national background very well in order to say something substantial, but I can say something about the general problem seen from a, let's say, legal and land rights perspective. One thing is that land rights are basic for development, which you also have in very underlined. And the organization of collective land rights is a problem in many countries, also in Norway. We have a court case going on in the Supreme Court today or yesterday about land rights in Finnmark, the summer land rights. The first real court case about that. The other thing is that much of our development, of course, is maybe more than many recognize is based on what has happened to land rights in the in Western world from 1850 to 1900 was very, very crucial. And the problem of the development we've had, we can look at that and maybe learn something from it, but I also would say that, of course, the situation is different. But you have pointed out some problems. One is that there is I think we've learned that there is a conflict. You can say that, well, these people in the ministry or in the forest authority should have the same, should be interested in giving people rights, but there are, when you have more industrialization, building of infrastructure, and so on, the conflict between the land rights and the people, and if their land rights are weakly defined, not easy to prove, not easy to enforce, they're very tempting for somebody else to just grab it or push them aside, which has happened also with the Sami people. There was also a dam in 1980 that created the protest that led to some changes. The other thing is that the last thing you said, point out, there is no quick fix. You cannot just take a law saying now you have rights. You have to establish systems which make it possible for the people to enforce their rights, to courts and to other systems. And I think that is, it has taken us now about 35 years to try to establish the rights in Finnmark, and we are still working on it. And I've come to learn that during the last years that ownership is not enough. You need what I call the infrastructure of ownership to make it possible to prove and to enforce. And there's in a way two problems for the people. And this is, I think, difficult, because you can make collective rights, but the people also have individual interests and individual needs to use the area. So one thing is to protect them against outsiders who try to take the land. The other is to try to establish systems which makes it possible for individuals to improve their situation and to make investments. And so I think what's probably needed is to have a system where I look at some of your written material also, a system which establishes some kind of individual rights. But then the problem is there has been a lot of discussion with this with the World Bank and based on hard and yeah, during the last 20-30 years, and there has been maybe too strong emphasis on establishing individual ownership rights to find this balance between the collective rights which you need in order to organize the use of sustainable use of their resources, and the individual rights which is probably needed in order to protect the rights is very difficult to hit, and I think your project will be interesting to follow, and hopefully you can give us some more understanding of this. Okay.
Okay. Do you have any? Do you want to respond?
I think
we could go.
Yes.
I think what we'll do is that I think this was very useful, and I think that thank you for bringing up the situation in Norway, because I think one thing that really shows is that India was actually really pioneering protection of land rights of indigenous people. And when that happened already in 1950. So as you were saying, I mean, we were in the 1980s struggling, and then sort of after this struggle, there were some more establishment of land rights of the Sami people. So I think that's also an important context, that the provisions in India have been working for a long time, and there has been attempts to establish infrastructure for a long time. Actually, this fits very well with the next session. So I think what we'll do is that now we'll have 2 more presentations, 1 more comment, and then afterwards, all of you will sit here and we'll discuss with the audience. So you can just sit down here. We will have, as Namita was saying, there is one of the states in the blue states, the states under what was called the sixth schedule, which gave more autonomy to the tribal population. One of these states have been a focus of study for the project in particular. And Hugo Stokke, who's a researcher at the CMI, and both of them, and Kavita Søreide, both based in Norway and at CMI, have been responsible for that. Both are political scientists. Hugo is Norwegian, has also looked at Sami rights actually in other contexts. And Kavita has her doctoral degree from University of Delhi, and has looked at federal politics in India before, and is now, which is also a very interesting aspect of this project. So we will first have Hugo say something about his work in Meghalaya, and then Kavita, and then Tone Sissener, who also is based at the University of Bergen, and who also does work on land rights in India, will give her comments to the 2. So please, Hugo, you can start.
What I will do, I will only speak about the state of Meghalaya, because that's what I've studied. So I'm not going to speak about the rest of Northeast India or about the rest of India as a total. What I basically want to make out is an argument about the uniqueness of Meghalaya. And I call my paper Between the Lines, and that is if you like, a metaphor for the state of Meghalaya in the sense whether it wants to be inward looking to try to protect their system and their resources against any outside negative interference, whether it wants to be outward looking in order to better integrate legally and other ways with the rest of India. So my perspective will basically be, top down, and I will do so by looking at legislative developments and also some court cases that might be an illustration of this tension between an inward-looking and an outward-looking strategy in terms of the government. So first, one important historical legacy, which I think is needed to understand the situation in Meghalaya today, is a regulation from the colonial period, which was known as the Bengal Eastern Frontier Regulation. And that regulation introduced the concepts of excluded and partially excluded areas, meaning those areas that were excluded were only accessible through special permission by the colonial government, and those areas were partially excluded, and there were less restrictions both on Indian nationals or on foreigners. And this ties in historically with a long tension between the plains, where you basically have the sedentary population in many cases, and the hills, and where you find the majority of the tribals. So there is a hill-plain contradiction which has been there for a very long time. And for those who have read Jane Scott's book about the art of being God, they will recognize the background there. Now then, in order to protect its demographic population, the indigenous, if you like, or the tribals have been very keen to stem or to counteract the influx of migrants from other parts of India, but also from the neighboring state of Bangladesh. And there has been a clamor in order to, what they call, introduce the so-called inline permit, which I mentioned was enforced during the colonial period. However, the problem has been that the inland permit, the landslide relation, only applied to certain parts of the current state of Meghalaya, and it was repealed for the Garavus, which was another part of the current state. So therefore, the state is not in a position to introduce this regulation for the entire states. So therefore, what it has been trying to do is to introduce a bill on the regulation of landlords and verification of tenants from 2013, which is basically meant to register all inhabitants of Meghalaya in order to keep an eye on the scale and volume of immigration. But that applies to all the inhabitants, all residents of Meghalaya, to indigenous as well as those from outside the state. And some of the criticism has been, particularly from the civil society, that this regulation, or this bill, is not good enough, to reduce and stem immigration. And it's a bill which is basically still pending. Now, I think Kamita will probably talk more about governance, the state of governance in the state, which I can tell you is hugely complicated. In fact, you can say it's a three-tiered type of government, or it's even a four-tiered type of government or governance, because right at the top you have the federal state based in Delhi, and you have the legal institutions, both from the Supreme Court and downwards, you have the High Courts and so forth. Then you have the state government, which is a fairly new creation. And in the case of Meghalaya, it came in the early 70s. Below that is the so-called autonomous district councils, which came with independence and which were introduced while what became Meghalaya was still a part of the larger state of Assam. And then below that again, you have again a three-tiered system of traditional governance with just the chiefs, with clusters of villages and village councils right at the bottom. Now the thing is that in order to make local democracy, local governments more democratic, the federal government introduced a bill which provided for the setting up of village development councils. And this was to make the local governance more in line with what is in other parts of India, where you have the local democratic system of governance known as Panchayati Raj. And these councils were to be open to all residents of the village. However, it was objected against this bill that the system in which these councils would be enveloped is not entirely democratic. Many of this is based on hereditary principles, and there's also a very clear gender bias in the sense that women take much less part in local government than men do. So, but anyway, this bill is still ongoing, and this I think is indicative of the situation. It was introduced in 2013, but now we talk about 2016, and it's still a bill, and we don't know the outcome of that story yet. I think more serious, which is another example I want to talk about, was a case that was brought before the Guwahati High Court, and it concerned a number of people. They were belonging to a very small tribal minority called Khmer, and they were thrown out of their village due to marrying non-tribals. And this was done by the village admin. And the case came before the court, and the court decided they were then allowed to return. But then in the court thought, for principal reasons, that a larger statement had to be made. But it basically turned out is that the court refused the right to the village headman to issue no objection certificates regarding residence, measure, and other civil affairs. Further on, there should be qualifications and eligibility for who is going to be elected headman in the village. Now, the Right to Information Act should be applied in order to check the accountability of those of the headman at the village, and they should be regarded as a public servant in order to have sanctions against them in case of corruption and so on. And finally, the Supreme Court, which took the case, they decided that these functions were to continue, but they still maintained that the order given by the High Court was valid. So the case now still stands in a state of uncertainty, and we don't know what will be the outcome, but it was clearly perceived by the local headmen as an intrusion into their powers and an attempt to streamline local governance as per the requirements of other parts of India. So I'd like to say a few words, because we're talking about land, and you have development programs. These programs are basically there to encourage the most productive use of the land. And of course one of the issues as regards pending legislation is that there is much less restrictions on the use of private land than there is on the use of communal land. So there is this saying that, those who know local, is rai kinti meaning private and rai rei meaning communal. And as for communal land, for instance, you have the regulation that the communalist land is not used for X number, that is, so to speak, reverts to the village. So this program then wanted to introduce land banks in order to give those who have too little land, an opportunity to engage in communal work, particularly protection of environment, forestry, and so forth. And they discovered that there is a huge variation between the different parts of Meghalaya in terms of who owns the land. In fact, most of the land in the Jaintia Hills, which is a part of the state, had to be purchased by the program because it was all in private hands. So, and that thing brings me to the final point, what I'm trying to make, namely the restrictions on the use of private land, those who are either held individually or within a clan. And I think this has been dramatically highlighted in the case of coal mining in Meghalaya, which is also known as rat hole mining. Now, this has been found by scientists, locally based scientists at the Northeast Hill University, to be extremely damaging to the environment, basically in terms of soil acidity, water pollution, and the side effect that this also has created problems downstream. So a case was brought by a student association in Assam before the National Green Tribunal to force the Meghalaya government to undertake environmental actions to improve the quality of the water. And what the Green Tribunal did was to put a moratorium, saying that no more coal is going to be mined unless there is a safe, scientifically based and regulated mining policy. Because the way the system ran was that these private individuals basically got a no objection certificate for the village headman, and there was no regulation of any type at the state level. So this was then to be stopped. Coal that had been extracted were to be sold, but unless the state government had introduced a proper mining policy, no more extraction was going to take place. So, and of course the discussion has been going on since then, also in the sense aggravated that you have accidents. You have accidents in the state leading to deaths of 15, 20 or more people, basically due to the hazardness of the mining. So, to conclude, and there's one final point is that then the state government argued that the union laws of mining are against traditional customary practices, and therefore referring to the state of the Meghallians under the 6th schedule, these laws do not apply. That's how it stands, but the case is still undecided. So just to conclude very briefly, the way I see it is you have two forces pulling in different directions. You have the government in Delhi, but you also have the court system. They very much want to introduce rational legal principles, rule of law, predictability, so on and so forth, which means weakening and revising significantly the system of the 6th schedule. So that's one part of the equation. On the other side, you have the creation from the 6th schedule, the district council, and the whole system of traditional government want to keep things as it is because that's how it was, and it's the best way to protect their identity. And the state, the government, because the state is not the creation of the 6th schedule, it's in between these two forces pulling in different directions. And it frequently results in stalemate and gridlock, both within the court system and within legislation. And we don't know, except one conclusion can be drawn that governance in Meghalaya is very, very ineffective. Thank you.
Thank you, Siri, and Namita for
Sorry.
nice introduction to Meghalaya. I would just briefly give my background. As Siri has already told that I worked on federal coalition politics in India, and then when I moved to Bergen and I had an opportunity to work on this project, so suddenly I was charging into new waters totally and trying to work my way through this complex of rules and legislation, and just to give an interesting snippet from one of my experience was that I have always lived in Delhi, and Northeast has this cultural, political divide with the rest of the peninsular India, and just to gain access to some people or to interview them, if I said that I was from Delhi, I was not given a very warm welcome. So I was very lucky to have Hugo, but besides him, my husband, who is a Norwegian. So just to show his face and gain access, and then I could just talk to people. So this was how I started off. Well, I just want to mention that these are some of the implications which I'm going to share today from an article which I'm trying to write, and these are merely implications because my work has been based on the article is based on the field work from a village in Meghalaya, and it's like sub judice, right? So they're like ongoing implications, but these are some of the main implications. They are just indicative, so they are not conclusions. So I'm not going to call them conclusions. So giving a brief background, the Scheduled Tribes is an official designation given to the groups of historically disadvantaged indigenous people in India. And these tribes, as Namita has mentioned, have historically and continue to stay on the fringes of growth in India, despite the presence of a very strong development state. But the people who have been concerned with the issues of marginalization and social exclusion of the indigenous people in India have often looked at this special constitutional provision, which is the 6th schedule, which Namita has mentioned, which applies to parts of Northeast Indian states. Now, why have they been so much interested in looking at the 6th schedule is because 6th schedule in a way is a protective mechanism. It has a host of provisions which in a way keep the indigenous people in the Northeast Indian states free from the rest of from the federal rules and regulations which apply to the indigenous people in the rest of India, in the peninsular India. Besides that, another important point is that the 6th schedule gives or recognizes the community's rights of ownership and control over their land, their forests and other natural resources. And often, very often, we come across that the people in the Northeast India which are governed under the 6th schedule, that means that those who are in the communities which are in control of their own land and natural resources are upheld to have apparently fared better when compared with their partners in the rest of India who are either under the 5th schedule or under no special constitutional provision. And as Namita also pointed out through her presentation, the HDIs, the socio-economic indicator, everything points out that these communities have performed better, they have scored better. And the question is it because of the 6th schedule? So that was my point of inquiry. So I would like to say here is that while there is an ongoing debate about the efficacy of the 6th schedule itself, the present work is an inquiry into the social dynamics of communities' ownership and control of land in Meghalaya. And Meghalaya was chosen primarily because it is the only Indian state which has 100% of its territory under the 6th schedule. So it was relatively easier to see the implications, how they have played out under the 6th schedule. But the objective, or specifically my objective, was not merely to look at the development debate in India on issues of social exclusion and marginalization of indigenous people as merely as the external threats which pose from the state, the Indian state, or from the private extractive resource industry. But it was important for me to see how the internal group dynamics, within community group dynamics, have played out under the 6th schedule. How far have they been able to provide or continue to provide that protective mechanism to the individuals within the communities which have this constitutional protections. So a little bit about the 6th schedule first. The 6th schedule was definitely a very unique and a bold step. Like Siri mentioned, we were far ahead in those terms, that we started it off in 1950s already. But it was definitely an act of political accommodation, because these are the indigenous territories which lay in the northeastern borders of India, and these were very vulnerable, porous and volatile borders with Bangladesh, Myanmar, China. So it was a sort of a political accommodation which the Indian state sought to proceed its engagement with these tribal communities by giving them a special constitutional provision wherein they can be, one, stay away from the host of federal laws which govern the rest of the indigenous people, but also that the communities can have control over their own land and natural resources. But what I would like to stress is that besides this political settlement, it is also important to realize that this was also a settlement between the Indian state and the social groups and not the individuals. So like Professor Ernst Nutwet said that about individual rights within the communal rights, so there is always this fine balance which has to be established, and which is the most difficult job actually. So whether or not the cause of individual justice was supposed to flow from this constitutional protection for the communal rights is something which has been the focus of my inquiry. And for example, communal land holdings exist in Meghalaya. which means that the community owns those lands. But and this was supposed to be an inbuilt social security net within these tribal communities for the most vulnerable and the poor amongst them. So whether the Indian Constitution had this as an original intent, that the cause of individual social justice would, by implication, then flow to the individuals, is of course open to debate. Now I would just like to point out what have been my observations from my fieldwork in Meghalaya. First of all, to begin with, there was an anomaly which existed within the whole institutional and the constitutional provision of the 6th Schedule. What was that? So the 6th Schedule gave, or it recognizes the right of communities to control land and natural resources, while it did not recognize the pre-existing tribal institutions which were dealing with control, regulation and management of land. So they gave recognition in essence to the idea of communal land, but they do not recognize the tribal institution hierarchies which existed and controlled these lands. Instead, they created special institutional bodies, the autonomous district councils, for different reasons. And this created, as you pointed out, a lot of overlaps, but a lot of confusions as well. So while the autonomous district councils were created, which are these new modern state institutional democratic representative bodies, the tribal hierarchies continued to exist. The tribal institutions continued to coexist. And this opened up a host of overlappings, because the people in Meghalaya continued to be strongly associated with these tribal hierarchies despite the presence of the ADCs. And this unfolded a number of, it unfolded this extreme interplay between the formal and the informal institutions. And this created new challenges and changes to the very idea of tribal land, because I'm concerned only with land. So it has come to light that the very idea of tribal land underwent a change due to the creation of this new tribal elite through the Autonomous District Council, the 6th Schedule system. And the clash and the changes between the tribal hierarchies, the pre-existing tribal structures, and the new structures helped to create this new elite, which then had a sort of a weakening effect on the social security system, which represented itself through the communal land. So basically, the new tribal elite was helping to aid the monetization and privatization of land. So while communal land, as I said, was a social security net for the most vulnerable amongst the communities, increasingly the elite within the tribes, within the communities, began to monetize land, began to individualize land, or began to privatize land. So this had a definite weakening effect on this pre-existing social security which existed through the idea of communal land, which was then given constitutional protection by the 6th Schedule. So therein, I think, lies the biggest anomaly of land politics in Meghalaya. And with this interaction between the formal and the informal institutions in Meghalaya, they got it was the whole activity got an impetus when the state-led development initiatives were set into motion, or extractive industries were set into motion. So what I'm trying to say here is that although state-led development initiatives or private resource extractive initiatives have heightened the conflicts, but the conflicts over land have largely been intra-communal conflicts. So they are like, we should not ignore the intra-communal land displacement which has taken place. And therefore, I would say that community land control and problems of marginalization or social exclusion amongst tribal communities are not two ends of a linear debate. So they are not mutually exclusive either. So my case studies have at least pointed that to me. And another interesting point was that these increasing conflicts have also led to increasing juridification over tribal land, which means while earlier people would approach the tribal bodies to settle land disputes, now because there are intra-communal, intra-tribal hierarchical disputes, they are approaching the courts. And again, there are no pre-existing land surveys or cadastral surveys in Meghalaya, so the courts or the state administration are again dependent on certificates from the tribal agencies to know like who owned the land. So in a way, the courts, there has been increasing juridification over land, but the process in itself has helped to reinvent and re-strengthen the tribal norms over land. So yes, like just to say it briefly, it's complicated, but I would not say that these are my conclusions, but definitely the implications from my fieldwork suggest that we need to look at intra-community dynamics when we talk about development debate over tribal and indigenous populations in Meghalaya. Thank you.
Very interesting. Thank you.
Thank you for this opportunity to comment on two very interesting papers on land rights and governance in Meghalaya.
I'm not sure.
Meghalaya. And please excuse any misreadings or any faults that may have been caused by little time to prepare, but let's see. In his book from 2013, Sanjoy Chakraborty takes up a pertinent problem in India, historically and contemporary. Setting the scene, Chakraborty writes, from special economic zones to power plants, from highways and airports to new factories and mines, from housing complexes to slum development, from scams and grabs to distressed sales and forced evictions, stories of conflict over land dominate the media and the popular imagination. Every voice in the political spectrum has spoken and continues to speak. Revolutionary, leftist, centrist and rightist, the growth-obsessed and the anti-capitalists, environmentalists and developers, business and civil society leaders, and of course, politicians and policymakers. At the center of all this is the question of land rights, and more specifically for the two papers presented here today, management of land rights and of tribal people in a particular region of India in a development perspective. The two papers somehow supplement each other. While Kavita takes a more local perspective for the understanding of distribution of land rights and the concomitant changing land relations in Meghalaya, Hugo starts with the legal and institutional framework, seeking to understand the effectiveness of legislative processes for the effective governance of the rights of traditional communities. Starting with Kavita's paper, she starts with a brief history of the sixth schedule and how it came into being in the context of independent India, letting us know how Meghalaya is the only state which has all its territory under this special constitutional provision. Here we are also told how the sixth schedule is meant to preserve a traditional order of ownership by restricting state ownership of land. Hence, Kavita writes, the role and relationship of the autonomous district councils to legislate on land and to regulate and manage land relations with conventional tribal bodies is a direct test of a modern state's attempt to engage with tribal conventions to achieve just distributary outcomes. In the following pages, she discusses the role of the role and power of the autonomous district councils vis-à-vis the state government on the one hand, and on the other, the tribal chiefs representing local interests, none of them seen as effective in preventing marginalization of the vulnerable. She then goes on to discuss why this is so and with what possible consequences through looking at a specific land acquisition case in a new township in Shillong. She says the interface between the traditional tribal and the modern legal systems of land management or mismanagement is symbiotically connected with the rise of intra-community conflicts over land and increasing privatization of communal land. As long as the two systems would stand disintegrated, the complexities and conflicts such as evident from the NST or the New Shillong Township controversy would also continue. Kavita goes on to claim that the land management practiced in the given cases can be seen as yet another example of increasing privatization of communal land, where the educated and the powerful members of the community and clan had converted right land into private land without the knowledge of the poor and uneducated amongst the community. The question thus arising is, who are the powerful and how are the poor in this context, and who are the poor in this context, and how are such distinctions made? In other words, I'm missing a broader discussion of local power hierarchies to understand the argument of, and I quote, a paradox of intra-community land alienation threatening the livelihood, security and social identity of the people who are protected by the legal constitutional provision of the sixth schedule. From the discussion, I am guessing that the most vulnerable includes the migrants once given land as described on page 9, but Kavita can perhaps tell us more about this, as well as shed some light on the proposed dividing lines more generally, that is, between the older and the younger generations, elite and common, rural and urban, educated and uneducated, which he says are not uncommon for any society. Also in Hugo's paper, the sixth schedule is the starting point for inquiries, but this time from a different perspective, from an interstate perspective vis-à-vis the Indian Federation. The focus here is on the competing and contentious pressures faced by the government of Meghalaya, pressure from below to preserve the institutions of the sixth schedule, the autonomous district councils and the traditional systems of governance, as well as pressure from above, from the federal center and from the court system, federally as well as regionally, and from development agencies, seeing the Meghalaya government as caught in the middle, trying to balance and fulfill various demands. The question is how the government manages such pressures. The first part presents a brief historical background, mapping the territory of inquiry for an understanding of its uniqueness. The inner line permit presented in section 3 supports the perspective of uniqueness and the related difficulties of regulating such a diversified territory, as well as the kind of opposition faced when trying to do so. Hugo then describes the structure of governance before moving on to scope for local governance in the context of competing powers of authority. Particularly, the courts are seen as undermining traditional governance structures by passing judgments against local ruling, as well as arguing against independent self-governing institutions at the local level. The contradictions and controversies between various levels of governance are particularly clear in regard to management of land rights and other resources, and in the implementation of various state-run development programs. In the conclusion, Hugo claims that the state is drawn between informal and customary rule and the legal rational rule of law most strongly represented by the courts. My reading of the paper suggests not necessarily a state caught between the lines, but rather a state trying to take control of local bodies of governance, but again and again failing to do so. Reading both papers, though in different ways, and Hugo also mentioned James Scott's, but this time Seeing Like a State came to mind. Recalling why he embarked on the project, writing the book in the first place, Scott says in the introduction, and please allow me to quote his analogy between beekeeping and statecraft. In pre-modern times, the gathering of honey was a difficult affair. Even if bees were housed in straw hives, harvesting the honey usually meant driving off the bees and often destroying the colony. The arrangement of brood chambers and honey cells followed complex patterns that varied from hive to hive, patterns that did not allow for neat extractions. The modern beehive, in contrast, is designed to solve the beekeeper's problem. With a device called a queen excluder, it separates the brood chambers from the honey supplies above, preventing the queen from laying eggs above a certain level. Furthermore, the wax cells are arranged neatly in vertical frames, 9 or 10 to a box, which enable the easy extraction of honey, wax and propolis. Extraction is made possible by observing bee space, the precise distance between the frames that the bees will leave open as passages rather than bridging the frames by building intervening honeycomb. From the beekeeper's point of view, the modern hive is an orderly, legible hive, allowing the beekeeper to inspect the condition of the colony and the queen, judge its honey production by weight, enlarge or contract the size of the hive by standard units, move it to a new location, and above all, extract just enough honey in temperate climates to ensure that the colony will overwinter successfully. I'll leave you with that analogy. Thank you.
Thank you, Tina. I think we've had a lot of very interesting perspectives here. Time is almost up because we started a bit late. But what I will do is that I will not allow you to respond, but I will allow some comments and questions that you can take into the further work. If there are anyone who would like to have some thoughts, who would like to make some remarks. I think everybody wants. If not, I think everybody wants coffee. Then I will let you. No. Okay. Colbert, please.
Okay, thank you very much. My question is directed to you. You mentioned the question of representation by special seats. I just want you to explain how that then translates into effective representation on the ground. These situations where the choice of the representative does not reflect, maybe the representatives are not picked from the tribal people of the ground. Maybe somebody is maybe politically connected, or he is picked from the city and has no connection with the, maybe by ancestral blood, but on the ground is not connected to the tribal. So how does that translate into effective representation on the ground?
I think that what I will do is that I'll let you can answer this, but also comment. I'll let you have a short comment each.
Okay.
So Ramit can start and then we'll just go around. Yeah?
But are there no other questions?
No, I think that's fine. So that's why you get to speak.
Thank you. So also, I'll respond to your question, but just also to what you said, and I think Siri mentioned as well. I painted a very critical picture of what is going on in India, but when I compare this with the protection of indigenous people in other countries, in some respects India does much better. And so, for instance, the fact that we had this protective framework in place since 1950, so you mentioned, and you mentioned that what is happening with the Sami people in not only in Norway but also Finland and Denmark. And the fact that the representation of the Sami people in the tribal in the parliament is just an advisory body. It is not a direct representation of the Sami. So the Sami parliament is merely an advisory body to the elected representatives. It is not directly participating in electoral in the decision making and law making for the people. So in that sense, it is a very low level of protection compared to what we have in India. But I think that what I tried to show that even with the kinds of protective provisions that we have for the people in India, for the tribal people in India, and I think India is also interesting in some ways. It is more comparable, of course, comparable to the Sami, comparable also to the situation in Africa, but distinct in many ways from the situation of indigenous people in countries like the US, Canada, Australia, and so on, because the kind of disconnect between the people who are now classified as Native American and so on, and the settlers who came from outside, that kind of sharp disconnect is not so much there in the Indian context, because the people who are considered tribal people are not so distinct, have their distinct ways of, but the other people have also been settled there for many hundreds of years. So in that sense, the question of indigenous people becomes a little bit difficult as well, because even the people who are non-tribals and who are also living in those areas have been living there for hundreds of years. So it becomes tricky there. But in specific response to your question, I completely agree with you that there is no effective representation. So there are multiple levels on which there is no effective representation. There is no effective representation because, as I said, only 30% of tribals are living in the scheduled areas, or the fact that and because it is a first past the post system means that you at least have to get a certain majority of the votes, which means that you end up representing both tribal and non-tribal interests. And my interactions in our field work, and also there was a workshop of tribal MPs, the representation is not insignificant. There are 50 MPs in parliament out of 500 who are tribal MPs. So 10% of the MPs are actually tribal MPs. But if you see the way they vote, they never vote on tribal issues. No, they vote along party lines. And so there are issues in terms of the MPs' representation, again on 2 or 3 different levels. One is that they only take the party line. The second is that, as you mentioned, they come often from the creamy layer. Although I believe that based on at least the fieldwork interviews in Andhra Pradesh, may be changing in terms of the generations as they change, that the more recent crop of MPs is more because the tribal people have also gone through more better education and so on, so more and more people are coming up, so that might change, but it does remain the fact that they are really limited only to their constituencies. They don't think broadly in terms of creating a tribal identity. It's simply not there. It's not even there in their consciousness when you speak to them. So no, in that sense, there is no effective representation of the tribal interest. But what is the tribal interest is also the question, because as I said, in Andhra Pradesh there are 33 tribal groups. And so, obviously they are not all being represented even by the tribal person, because they don't want to necessarily represent. There are conflicts between tribes. In Gujarat, there is one tribal group that is 47% of the tribal population. He's not going to represent the interests of the other 28 groups because they are competing for the same benefits. If you look at between the 5th schedule and the 6th schedule, historically, the 6th schedule states have had higher levels of education, etc., etc. So if you look at the reservations for tribals in government jobs and so on in government institutions, they are more from the northeast than from the central Indian belt. So the historical disadvantages are continuing in that way, even with the protective provisions, and it's the more superior tribes in terms of levels of development and levels of connection with the mainstream that are actually cornering the benefits.
Thank you.
Yes, short from you.
Yeah, very briefly, this is exactly what is the situation in Meghalaya, which is a tribal majority state. And while there is political representation, but it has also helped to create a tribal elite, right? And which is in direct conflict with the existing tribal hierarchy. So in a way, now the tribal institutions are trying to enter the democratic field and get elected. And another thing specifically with Meghalaya about representation is that, as Namita said, that this is after all about party politics. So once you introduce party politics, which was done in the case of Meghalaya as well, it is actually an instrument by the federal state to federalize its territories, right? So it has both the effects to it. Thank you.
Yeah, thank you very much, and thank you to for reminding me about James Scott and the beehive analogy. There is something there, absolutely. You may have heard, at least I read about this new field of study within anthropology called zombie studies, and this basically denotes the hilly areas, between the Himalayas, stretching all the way east, to Cambodia and to parts of Vietnam, and even, southwestern parts of China is part of that picture. Thailand, Burma, Laos, and so on. And this is the Asian struggle between the plains and the hills. And it was, as I briefly mentioned, it was British policy to leave the hills to themselves, more or less. There was local self-rule, and they could pretty much take care of their own business, according to traditional customs and so on. But on the other side of the coin was that the British didn't do much to develop those areas at all, because they didn't probably see much commercial potential in the hills, and therefore the focus was on developing the plains. Another thing is that the northeast is really special because it's, for one thing, it's bordering on very many countries, it's bordering on China and Burma in particular. But secondly, it was also so split off, in a sense, almost entirely split off from the rest of India after partition in 1947. It's a very thin corridor linking the northeast to West Bengal and the mainland India. So it has come to see itself as being different, something apart, from the Indian mainland, and that maybe was reflected in their attitude towards Kavita when we were doing field work, that a white man coming from Norway is less suspicious than an Indian coming from Delhi. And I think it's still there, this is very much the current situation.
I would just like to add something very interesting I came across just yesterday, and like we talk about Meghalaya and India, and that we said that we started off quite early with protective law for the indigenous people, but basically it all boils down to the question of common property as vis-a-vis collective property. And I was reading the rise of feudalism, in fact, is based on that how, for instance, people had something which is called as common property, which is a part of common law, and these lords who were supposed to be stewards for these properties and to make sure and settle disputes and blah blah blah, but eventually they ended up actually privatizing that land for their own favor, and this gave rise to feudalism in Europe. So I think in a way it's not very different to what we see in Meghalaya, and it was something very interesting which I wanted to share with you. Thank you.
Thank you so much all. This was